The second session is called Rules and Algorithms, and I'm really happy that we have combined here the panel with our own Estonian scholars and practitioners, together with our colleagues from Spain and from Italy. And I truly hope that we will have a very academically very interesting and fruitful discussion. First, I would like to introduce our first speaker of this panel, Professor Madis Ernits, who is also works as judge in Estonian court system, but he also has experience in European Union courts in Luxembourg and has different significant positions, including judge of Tartu Court of Appeal and also at the European Court of Human Rights, and also been a lecturer of law at the University of Tartu. And his academic achievements also include his PhD in law from the University of Tartu, and has been actively involved in numerous international legal training programs and workshops. And I'm also very happy that Madis Ernits is now also visiting professor of Tallinn University. So please, Madis, the floor is yours.
Thank you very much. I know this is the most difficult moment in every day after the lunch, but I will do my very best to keep you from falling asleep. Let's try this. AI programs are designed to understand spoken word, to translate from one language into another, to recognize images and objects in the physical world, etc., etc. In the administration of justice, the use of AI programs raises internationally. States like China, with a robot judge, India, Singapore, Brazil, Mexico are the pioneers in this field. But what about the use of AI in Estonian courts in the light of the newly adopted European legislation? In the EU, the overarching objective of the recently enacted Artificial Intelligence Act, or AI, which was enacted on the basis of Article 114 TFEU and partly Article 16 TFEU, is to ensure appropriate framework conditions and protection standards for the use of AI in accordance with European fundamental rights. The AI entered into force on the 1st August 2024, but it shall gradually become applicable over the coming years. The AI is the first ever comprehensive legal framework of AI. Generally speaking, the AI pursues a cross-sectoral regulatory approach. The scope of application covers the development, commercialization, and the use of AI systems by private and state actors alike. The regulatory approach of the AI is risk-based. The greater the risk, the more intensive the measures. Okay. The AI provides for a 4-stage risk management model, from the highest to the lowest risk level. First of all, prohibitions. Secondly, prohibitions with reservation of authorization. Thirdly, quality requirements for high-risk AI systems, and on the fourth place, labeling requirements. In terms of the regulatory model of the EIA, the specific use of AI in courts is on the third level. That is, it is in the area that harbors a high risk. Thus, it is not prohibited per se, but it is a subject to all the precautions and restrictions of the high-risk use. However, there are cases in which the use of an AI system in courts proves to be an unacceptable risk. In these cases, the first stage, the prohibition, applies. Furthermore, AI assistants that do not exceed the threshold of high risk are also conceivable. This would be then assigned to the fourth regulatory level. In terms of AI, risk means the combination of the probability of an occurrence of harm and the severity of that harm. The higher the probability or the higher the severity of harm, the bigger the risk. Although the high-risk AI systems are the main focus of the AI, the concept high risk is not separately defined in the AI. Based on the risk definition, a risk shall probably be classified as high not only when there is a high probability of a severe harm, but also in case of a very high probability of not so severe harm, or not so high probability of very severe harm. However, it remains to be seen in practice whether the line between the high and limited, or actually, more precisely, medium risk, will be drawn. The AI characterizes the high risk in more detail by a positive catalogue of fields of application. The high-risk usage while administering justice is described as follows. This is in the Annex 3. AI systems intended to be used by a judicial authority or on their behalf to assist a judicial authority in researching and interpreting facts and the law and in applying the law to a concrete set of facts. The justification why such systems shall be classified as high-risk systems is delivered by the recital 61. Certain AI systems intending for the administration of justice and democratic processes should be classified as high risk, considering the potentially significant impact on democracy, the rule of law, individual freedoms, as well as a right to an effective remedy and to a fair trial. In particular, to address the risks of potential biases, errors, and opacity, it is appropriate to qualify as high-risk systems intended to be used by a judicial authority or on its behalf to assist judicial authorities in researching and interpreting facts and the law and in applying the law to a concrete set of facts. Thus, according to the Annex 3, number 8, the following requirements must be met. First, in order to open the scope of application of the AI, there must be an AI system in the sense of this regulation. Secondly, the actor must be a judicial authority or somebody else on their behalf. And third, there must be an intention. Intention to use the AI system to assist a judicial authority in researching and interpreting facts and the law and in applying the law to a concrete set of facts. So let us take a closer look to the aforementioned regulatory framework for the AI systems that affect the administration of justice. So first, the AI system. It is defined by the AI itself, and it says that an AI system means a machine-based system that is designed to operate with varying levels of autonomy and that may exhibit adaptiveness after deployment, and that for explicit or implicit objectives infers from the input it receives how to generate outputs such as predictions, content, recommendations, or decisions that can influence physical or virtual environments. Recital 12 of the EIA provides for assistance with the interpretation regarding the intentions of the legislator. And the most important sentence in this recital is that the key characteristic of AI systems is their capacity to infer. The definition of the AI system was one of the more contested issues in the Act, needing to strike a balance between providing a comprehensive definition that would encompass new developments, whilst also ensuring it was not so wide and as to inadvertently capture software which would not generally be classified as AI. The definition provided for by the EIA is, by the way, similar but not identical to the internationally influential definition provided for by the OECD recommendation on artificial intelligence from 2018. So we see here clearly a similarity. And moreover, the EIA definition is not the first definition of an artificial intelligence in a legal act. In 2020, at least, the US Congress passed the National Artificial Intelligence Initiative Act that provided for a definition of the artificial intelligence. However, perhaps somebody who knows more about it can provide us for more background to this. This is, I searched, but I didn't find what is this actually about. So there are some recognizable similarities to the EIA definition as well. Despite the legal definition now being available, it is far from clear what we mean by an AI system. First of all, the concept of intelligence that is included in the concept of artificial intelligence is by itself not clear. To put this in the words of the European Commission's high-level expert group on artificial intelligence, the term AI contains an explicit reference to the notion of intelligence. However, since intelligence, both in machines and in humans, is a vague concept, although it has been studied at length by psychologists, biologists, and neuroscientists, AI researchers use mostly the notion of rationality, which refers to the ability to choose the best action to take in order to achieve a certain goal, given certain criteria to be optimized and the available resources. Of course, rationality is not the only ingredient in the concept of intelligence, but it is a significant part of it. As a consequence of that, some authors recommended only 3 years ago that policymakers should not use the term artificial intelligence for regulatory purposes, because there is no definition of AI which meets requirements for legal definition. However, it was done, and we have it now here in front of us. This definition has been also criticized for other reasons, but I would leave this in this place and we will move forward to the next topic. So much has been left here by the definition for the courts and for the interpretation in the future. So the second criterion is a judicial authority. In Estonian, it's õigusasutus, which seems to be a rather misleading translation. The term judicial authority should be interpreted based on the general interpretation criteria, according to the meaning and purpose of the regulation. I would argue that there are actually two separate meanings of the judicial authority in this regulation. On the one hand, this term occurs in the context of authorization requirement. That means a judicial authority should authorize the use of AI in certain contexts. And in this context, it should most probably be used and understood as in the narrow constitutional sense. That means it is a court in the sense of national constitution. For Estonia, for instance, the court as an institution which can be county and administrative court, court of appeal, or the Supreme Court. On the other hand, in the context of the definition of the high-risk use of the AI, in the Annex 3, number 8, the judicial authority should be understood in the widest sense. And this is much wider than the narrow constitutional sense. This is the sense of Article 267 TFEU, which means that every court that can submit a preliminary question to the Court of Justice should also be a judicial authority in this sense. I would argue that this has to be meant in this way, because when we take it's easier to sleep for you. And I don't see who's sleeping. In this case, for instance, there are Public Procurement Review Committee, the Industrial Property Board of Appeal, or the Labor Dispute Committee in Estonia, which are not courts in the constitutional sense, but which are organs whose task is to solve disputes. And I would argue that these bodies would belong to the term judicial authority in this sense. But we shall see. We don't know yet. Some support by the interpretation gives us, again, the recital 61, which states AI systems intended to be used by alternative dispute resolution bodies for those purposes should also be considered to be high risk when the outcomes of the alternative dispute resolution proceedings produce legal effects for the parties. In addition to that, the activity on behalf of such judicial bodies is also included. However, this will not be further discussed at this point. So, and the third condition is the intention to use, to assist the judicial authority. It is not entirely clear what the scope of the concept of assisting judicial authority means, and how the line between assisting on the one side, a judicial authority, and on the other side, acting on behalf of the judicial authority, which is also included actually, should be drawn. However, it seems to be possible to state with a relatively high degree of certainty that an AI system that is designed to replace a human judge with a robot judge will be ruled out by this expression, because it would not anymore assist the judicial authority, but replace it. This is something else. This interpretation is actually supported by the Recital 61 again, where it states that the use of AI tools can support the decision-making power of the judges or judicial independence, but should not replace it. The final decision-making must remain a human-driven activity. So I would argue that in case of a robot judge, the prohibition regime applies. It's excluded. AI tools that intervene less or more in the judicial decision-making process are conceivable. We can imagine assisting tools with rather none or low impact to the decision-making process, like drafting routine court documents or procedural tracking, with medium impact, for instance, summarizing the facts of a case, to tools with significant impact, like rendering a full draft judgment. The AI systems that have none or low impact to the decision-making process would not constitute a high risk, and thus drafting routine court documents or procedural tracking would not classify as high-risk assistance. During the preparatory phase, I approached the current chief developer of AI applications for Estonian courts and asked him for some information. And, well, according to him, there is actually only one assistant used currently by Estonian courts that would qualify as AI. Only one. I thought there would be more, honestly. And this assistant is called Salme. It is about transcription of court hearings, and the AI element is not only makes a text out of an audio file, but also if a voice example is presented to it, it tries to find out when the particular person spoke and noted. Well, I learned this week that doesn't work right now since the last update. But we hope it will function again soon. In addition to that, we have the cleaner in preparation. And the cleaner's purpose will be cleaning court decision out of personal data. And now let's take a look. We have learned these criterions. We need to have an AI system. We need to have judicial authority and intention to use. By assisting, judging, so to say, to make it very brief, would Salme actually qualify as a high-risk assistant or not? I'm not certain myself. I don't know. Because there is, on the one hand, it could qualify as a high-risk AI system because it is intended to be used to assist in a broad sense, assist judicial authorities in researching and interpreting facts and the law, and in applying the law to a concrete set of facts. One could argue this. This sounds at least reasonable to me. On the other hand, we could also argue that it is the only purpose is to perform administrative tasks, which do not constitute any high risk, as exemplified by the recital 61 again. No, it's not here. It was, yeah, administrative tasks. There it is. The laser beam doesn't work. Okay, the very last sentence. Okay. So if it would belong to just performing only administrative tasks, we have no high-risk assistant at all right now. We would only have just simple assistants that assist us by the administrative tasks. The cleaner would clearly not belong to the high risk because it's excluded by the recital 61. And then we have this X law, which is actually publicly available and which not only adds references to relevant case law to the articles and paragraph of Estonian legislative acts, but and regulations, but also information or cross-references to the EU directives and regulations. It's actually a quite helpful tool. But in this case, I would say this is no AI system at all. This is already excluded from at least the present stage of development. It might be that it becomes one day when the AI, for whatever purpose, will be added. But right now I would argue that it is no AI system at all. So, when we have now a high-risk system, what happens then? The legal consequences of a qualification of an AI assistant as an AI system that is intended to be used to assist judicial authorities are the same as legal consequences for all high-risk AI systems. According to the EIA, high-risk AI systems shall comply with the requirements laid down in Chapter 3, Section 2. There are quite many paragraphs, articles. Particularly relevant for the AI systems that are intended to be used in courts seems to be this Article 14, Paragraph 1, according to which high-risk AI systems shall be designed and developed in such a way, including with appropriate human-machine interface tools, that they can effectively be overseen by natural persons during the period in which they are in use. So I actually thought, what would it mean now when we would qualify this SALME, which is recognizing the text and adding the speakers to the protocol? If we would recognize this as a high-risk system, what would this mean actually? What would this mean? And it seems to be that I would argue that the context of court proceeding, in the context, this requirement means that not only the judge, but also the parties to the proceedings must have an overview and the insight. This seems to me reasonable. In case of SALME, I would argue that everyone must have access to the audio recording and the right to demand a correction of the transcription if necessary. And that would be the requirement. And also, what is interesting, this Article 74, it may raise some some questions about the separation of powers. Because these bodies, surveillance authorities, they are executive power. But courts are judicial power. And when we have now executive power having surveillance over the judicial branch, it may raise some questions in the future. So we don't know yet because it doesn't apply yet, but I see there is a potential for some questions in the future. So my time is running up. What are the advantages of the AI? I would say that in the first place, it provides for a standardized definition of the term AI system, which will most likely have significance beyond the borders of European Union. It provides for a comprehensive regulatory framework also for administration of justice and thus a higher legal clarity and legal certainty. The AI excludes clearly a robot judge, but permits computer-based AI assistance. And the AI indicates clearly that AI systems that shall assist judicial authorities in researching and interpreting facts and the law and in applying the law to a concrete set of facts are operating in an area is considered as a high-risk area from the perspective of fundamental rights. And it results in the necessary safeguards. It is possible to categorize the AI assistants differently. Since deciding systems are clearly excluded, we have to concentrate on assisting systems in the future. For instance, Richard Susskind has divided assisting AI systems used in the legal field into expert systems and knowledge-based systems. We need to focus on developing new technologies that can better assist judges to resolve disputes and refine the issues that need to be presented to them. AI could significantly enhance efficiency by quickly analyzing and organizing legal documents, precedents, and evidence, potentially reducing case backlogs and ensuring more timely justice. AI could also advise judges looking out for relevant information and providing answers to questions presented to it. In this way, AI will not take away the work of judges, but is going to change it significantly. In order for AI systems to be able to process legal information effectively, the legal information must first be made machine processable. In the words of Tori Railing, in order for AI to work in accordance with Article 6 of the European Convention of Human Rights, this also means the following. It has long been known that bad data, such as legally incorrect decisions, reduce the quality of the AI result. But correct data is not enough. Text recognition with natural language processing, in which the text-driven behavior for lawyers and judges is calculated from the external perspective, can recognize patterns. Patterns such as statistical relations are not enough to substantiate the judgment. For the AI to be able to process and understand legal information, that information needs to be enriched, structured, and provided with legal meaning. Adding legal meaning in the form of structured terminology and defined relationships will further increase the effectiveness of AI in the court process. AI should be able to explain how it came to its result. This can be an explanation of the processing process, but also a substantive explanation. Research shows that AI in general should be technically capable of the kind of explanation that we now ask from humans, but that in practice, human can explain some aspects more easily than AI. I'm already over time. I would just come to an end and leave it to this. I would finally leave you this famous quote of John Searle, which I think is correct. Just computer has syntax but no semantics, at least not yet. And for the semantics, human judges will remain responsible. Thank you very much.